There is one document that overrides your will every single time. And if you have not reviewed it in the last 12 months, your entire estate plan could already be directing your assets to someone you never intended. It does not matter how much your lawyer charged you. It does not matter how carefully your will was prepared. It does not matter if you updated your will last month. If this one document states something different from your will, this document prevails. Not sometimes. Not in certain states. Every single time. Federal courts have ruled on it. State courts have ruled on it. The United States Supreme Court settled it unanimously. The document overrides the will. But here is what your estate attorney probably never told you. There is not just one of these documents. There are at least 5 different versions hidden inside accounts you already own. And the most dangerous one is inside an account most seniors have not reviewed in over a decade. By the end of this video, you will know exactly where all 5 are located, what they control, and the one error that turns a simple document into a $400,000 disaster for your family. This document is called a beneficiary designation. You completed one the day you opened your 401k at work. You completed another one when you purchased your life insurance policy. Your bank may have asked you to complete one. Your brokerage may have one on file. You signed these documents years ago, probably never thought about them again. And that is exactly where the problem begins. A beneficiary designation is a legal contract between you and the financial institution that holds your money. It tells that institution one thing: who receives the money when you die. And when you die, the institution follows that document. Not your will, not your trust, not your handwritten letter, not a verbal promise you made to your children at the kitchen table. They follow the document because legally the document is a contract and contracts override wills. And here is the part that makes this so dangerous. The financial institution does not investigate. They do not call your family. They do not check your will. They do not ask whether the person on the document is still the person you would choose today. They see a name, they send the money, and once that money is sent, getting it back is nearly impossible. This is not a loophole. This is federal law. Let me show you how badly this can go. A man named William Kennedy worked for DuPont for over 20 years. He had an employer retirement plan worth over $400,000. When he first enrolled in the plan, he named his wife as the beneficiary. That made sense at the time. They were married. She was the obvious choice. Years later, they divorced. After the divorce, Kennedy did what most responsible people do. He went to his attorney and rewrote his entire will. He made it crystal clear everything goes to his daughter. He signed it. It was notarized. It was legally valid in every way. But he never called DuPont to update the beneficiary designation document on his retirement plan. He may not have even remembered the document existed. It was a piece of paperwork he signed 2 decades earlier on his first day enrolling in the plan. When Kennedy died, his daughter assumed the money was hers. The will said so in plain language. There was no ambiguity, but DuPont sent the full $400,000 to the ex-wife because the beneficiary document still had her name on it. Kennedy's daughter sued. She had the will. She had her father's clear intent. The case went through the federal courts and eventually reached the United States Supreme Court. The court ruled unanimously. The beneficiary designation document controls the will is irrelevant. The daughter received nothing. $400,000 gone because of one document he forgot to update. And this is not rare. A study by the American Association of Retired Persons found that nearly 40% of Americans with retirement accounts have not updated their beneficiary designations in over 5 years. 40%. That means millions of seniors right now have documents on file that do not reflect who they actually want to receive their money. Divorces happened, remarriages happened, spouses passed away, grandchildren were born, life changed in every possible way, but the document stayed frozen in time because nobody picked up the phone and changed it. Therefore, the question every senior needs to answer right now is not whether your will is up to date. The question is whether every beneficiary designation across every account you own matches what your will actually says. Because if there is a single conflict between the two, the document wins and your family loses. Here are the 5 places these documents are located right now. Number 1. Your 401k or 403b. If you ever worked for a company, a school district, a hospital, or the government, you have a retirement plan with a beneficiary document on file. The average 401k balance for Americans between the ages of 60 and 69 is $232,000. That entire balance is controlled by the beneficiary document. Your will does not touch it. Your trust does not touch it. The document is the only one that matters. Number 2, your IRA. Traditional, Roth, SEP, it does not matter. Every IRA has a beneficiary designation. And here's the trap that catches more retirees than almost anything else. If you rolled your old 401k into an IRA when you retired, the beneficiary designation did not roll over with it. That old document stayed at your old employer. When the money landed in the new IRA, you signed a brand new beneficiary document at the IRA custodian. Maybe you filled it out carefully. Maybe you checked a box in a rush because it was one of 15 documents they handed you that day. If you do not remember exactly who you named on that new document, that is the problem. Number 3, your life insurance policy. The average life insurance death benefit in the United States is $350,000. That payout goes directly to whoever is on the beneficiary document. And life insurance policies are where this problem gets the most painful, because people buy these policies young and hold them for decades. A woman in Ohio lost her husband after 32 years of marriage. He had a $250,000 life insurance policy. She assumed it was hers. They had been together for over 3 decades, but her husband had originally purchased the policy during his first marriage and had listed his first wife as the beneficiary. He never updated it after the divorce. He never updated it after the remarriage. For 32 years, that document sat in a filing cabinet with the wrong name on it. His second wife, the woman who spent 32 years by his side, received nothing. The first wife, who he had not spoken to in decades, cashed the check within 60 days. Number 4, your bank accounts. Most banks offer a feature called payable on death, and many seniors sign up for it without fully understanding what it does. A payable on death designation sends your entire bank balance directly to the named person when you die. It skips probate entirely. It also skips your will entirely. You may have added this to your checking or savings account years ago because the bank suggested it as a simple way to avoid probate. But if the person you named is no longer the right choice, or if your family situation has changed, this document is quietly overriding your entire estate plan right now, and nobody knows it until you are gone. Number 5, this is the most dangerous one I mentioned at the beginning of the video, your brokerage account. If you have stocks, bonds, mutual funds, or ETFs at a firm like Schwab or Fidelity or Vanguard, there may be a transfer on death registration on file. Some of these accounts hold $300,000, $500,000, even over $1 million. This document sends the entire account balance directly to whoever is listed with no court involvement, no probate process, and no input from your will whatsoever. Seniors who set these up in their 50s and never looked at them again are sitting on a ticking time bomb for their families. And because brokerage accounts often grow significantly over the decades, the amount at stake today may be 3 or 4 times what it was when you originally signed the document. Now, let me show you the 4 mistakes that cost families the most money. The first mistake is naming your estate as the beneficiary instead of a real person. This sounds logical, but it is one of the most expensive errors in estate planning. When you name your estate, the retirement account gets pulled into probate. That means attorney fees, court costs, and delays of 6 months to over a year. But the real damage is the tax hit. When a spouse inherits a retirement account directly through a beneficiary document, they can roll it into their own IRA and keep deferring taxes for decades. When the estate inherits it instead, that spousal rollover option disappears completely. On a $300,000 IRA, this one mistake can trigger over $75,000 in accelerated federal income taxes that your family would not have owed if the document had simply listed a name instead of the estate. The second mistake is never updating after a divorce. In most states, a divorce does not automatically remove your ex-spouse from a beneficiary designation. Some states have laws that revoke a spouse upon divorce for certain types of accounts, but the rules are wildly inconsistent and they do not apply to employer retirement plans that are governed by federal ERISA law. Federal law overrides state law in those cases. If your ex-spouse is still on the document, assume they are getting the money until you call the institution and confirm otherwise. The third mistake is naming minor children or grandchildren directly. If you list a child under 18 as a beneficiary, the financial institution cannot legally hand them the money. A court will have to appoint a legal guardian to manage the funds on the child's behalf. That triggers court oversight, annual reporting requirements, attorney involvement at every step, and guardian fees that can eat $20,000 to $30,000 out of a $200,000 account before the child ever sees a cent of it. The fourth mistake is the one that turns all of this into a tax emergency. Before the year 2020, if your child inherited your IRA, they could stretch the distributions over their entire lifetime. A 45-year-old inheriting a $500,000 IRA could take small withdrawals over 4 decades and let the rest of the money continue to grow tax-deferred. But Congress changed the rule. Now most non-spouse beneficiaries must empty the entire inherited IRA within 10 years. Let me put real numbers on this. Say you have a $500,000 traditional IRA and you leave it to your son who earns $120,000 a year. Under the 10-year rule, he must withdraw the entire $500,000 within a decade. If he takes $50,000 per year, that pushes his annual taxable income from $120,000 to $170,000. At that level, he jumps from a 24% federal tax bracket to 32% on those distributions. Over 10 years, that 8% difference alone costs him $40,000 in extra federal taxes. And that does not include the state income taxes on top of it. Therefore, your beneficiary designation does not just control who gets the money. It controls how fast the IRS takes their cut. If the document is wrong or if the document names the wrong person in the wrong way, your family pays the maximum tax bill and there is nothing they can do about it after you are gone. And here is one more thing that surprises people. A power of attorney does not fix this. Many seniors assume that if they become incapacitated, their power of attorney can step in and update the beneficiary designations for them. Most financial institutions will not allow it. A power of attorney typically authorizes someone to manage your money and pay your bills while you are alive. It does not authorize them to change who receives the money after you die. Therefore, the only person who can fix a beneficiary designation is you. And the only time to do it is right now, while you are still able to make that phone call. Here's what to do this week. Step 1. Call every financial institution where you hold an account. Your 401k provider, your IRA custodian, your life insurance company, your bank, and your brokerage. Ask them one question. Who is currently listed as the primary and contingent beneficiary on my account? Do not guess. Do not rely on your memory of what you think you filled out years ago. Get the actual name that is on file right now. Some institutions can tell you over the phone. Others will mail or email you a copy of the document. Either way, get it in writing. Step 2. Compare every single document to your current will or trust. Line them up side by side. If any name on any document does not match your estate plan, the document is what the institution will follow, not the will. Update the document immediately. Step 3. If you have a revocable living trust, ask your estate attorney whether any of your retirement accounts should name the trust as beneficiary instead of an individual. This is not always the right move because of the tax implications I just explained, but it must be a deliberate decision, not an accident left over from a document you signed 15 years ago and never looked at again. Step 4. If you have been divorced at any point in your life, check every document across every account, even the ones you are certain you already updated, especially the employer retirement plan and the life insurance policy. Those are the two that families fight over in court more than any others, and those are the two where the wrong name costs the most money. Step 5. Do not name minor children or grandchildren directly as beneficiaries. Name a custodian under your state's Uniform Transfers to Minors Act, or name your trust with specific provisions for how the money should be managed until the child reaches the age you choose. One phone call to the institution that holds your largest account could save your family $400,000. So make that call before the end of this.